Hello everyone, Andrew Reed here, Juris Doctor and former LexisNexis head representative. We're going to talk about the Canadian criminal law, specifically elements of specific serious offenses. So let's go ahead and get started. And we're going to talk about predicate offenses first. So a true predicate offense has no accompanying mens rea requirement for prohibited consequences. There's three exceptions to this. The objective foreseeability test is required in addition to proving standard causation, which is the NETA test, to satisfy the actus reus and mens rea requirements. For 1, manslaughter, section 234 plus 236, or sections 219 plus 220. This is from the Creighton case of 1993. This can be either unlawful act manslaughter or criminal negligence manslaughter. So with unlawful act manslaughter from the Creighton case, the test for the mens rea of unlawful act manslaughter is objective foreseeability of the risk of bodily harm, which is neither trivial nor transitory in the context of a dangerous act. Foreseeability of the risk of death is not required. This test does not violate the principles of fundamental justice under Section 7 of the Charter. Also note the mens rea requirement of foreseeability of harm is entirely appropriate to the stigma associated with the offense of manslaughter. By the very act of calling the killing manslaughter, the law indicates that the killing is less blameworthy than murder. Nor does the sentence attached to manslaughter require elevation of the degree of mens rea for the offense. So unlawful act manslaughter test, objective foreseeability of death, or non-trivial, non-transitory bodily harm. Okay, and for criminal negligence manslaughter, the mens rea for this offense was not explored by the Supreme Court of Canada in Creighton, but it was touched upon in a later case called Tutton, which still does not establish a specific mens rea requirement as to whether there is an objective or subjective fault standard for Section 220. Normally for Section 219, to establish that the accused conduct was negligent, we would apply the modified objective test, per Beatty, which modified the marked departure standard in Hundau. The marked departure standard in Hundau. So, 1 is the accused conduct, A, a marked departure from the objective norm, gross negligence, or B, a marked and substantial departure from the objective norm, Section 219, criminal negligence, or 2, does evidence about accused actual state of mind raise a reasonable doubt as to whether a reasonable person in accused position would have been aware of the risk created by the accused's conduct. Okay, for Section 220, which is the causing death part of the actus reus elements. So this is a purely objective foreseeability of death mens rea standard from the Creighton. Is that test sufficient? Or should we use the slightly more subjective standard of the modified objective test from Beatty/Hundau? In Tutton, the court's majority favored a more subjective perspective, but there was also argument toward an objective standard with respect to the prohibited consequence of death in negligence manslaughter cases. And they say that in that case that the accused conduct must be evaluated in relation to the facts existing at the time and in relation to the accused's perception of these facts. Since the test is objective, the accused's perception of the facts is not to be considered for the purpose of assessing malice or intention on the accused's part, but only to form a basis for conclusion as to whether or not the accused's conduct, in view of his perception of these facts, was reasonable. Again, that's from the Tutton case. For aggravated assault, also falls under this banner, from R.V. Godden, Supreme Court of Canada in 1994, the mens rea required for Section 268, subsection 1, aggravated assault, is objective foresight of bodily harm. That's from the Godden case. It is not necessary that there be an intent to wound or maim or disfigure. The section pertains to an assault that has the consequences of wounding, maiming, or disfiguring. Important distinction there. Next and finally, we have unlawfully causing bodily harm from the De Souza case of Supreme Court of Canada in 1992, which says that objective foresight of bodily harm should be required for both criminal and non-criminal unlawful acts which underlie a Section 269 prosecution. I can see no reason why there should be a difference between the two categories of acts. Unlawful act equal POA or true crime, and the Crown must prove underlying offense as well. Okay, moving on to homicide. So a lot falls under homicide. Let's talk about it. Section 222, subsection 1, directly or indirectly by any means causes death. This is from the Criminal Code. Section 222, subsection 2, homicide is culpable or not culpable. Section 222, subsection 3, if it's a non-culpable homicide, there is no offense. Section 222, subsection 5, most common types of culpable homicide involve situations where death is caused by A, an unlawful act, or B, caused by criminal negligence. And finally, section 222, subsection 4, lists the types of culpable homicide. We've got murder, manslaughter, and infanticide. Okay, let's talk about manslaughter, and we're going to be moving down the left column until that's complete and then going to the right column. So with manslaughter, section 234, culpable homicide that is not murder or infanticide is manslaughter. Murder can be reduced to manslaughter where there is provocation from section 232. Section 234 covers unlawful act manslaughter, where an unlawful and dangerous act plus objective fault from the Creighton case. Sections 219 and 220, manslaughter can also be criminal negligence causing death. So there's a duty to act, which is established in section 219. Failure to act is an omission to act. Criminalization of the particular omission to act is found in section 220. And also remember, important, manslaughter is a lesser included offense of murder. Okay, let's talk about murder. Over here on the right side, section 229. Culpable homicide is murder where A, where the person who causes death of a human being, or 1, means to cause his death, or 2, means to cause him bodily harm that he knows is likely to cause his death, and is reckless whether death ensues or not. And section 229, subsection B, doctrine of transferred intent from R.V. Drosto, 1984. 229C, is it still murder even if you had not intended to cause death, but you did something you knew subjectively would be likely to cause death, which is defining transferred intent. Section 231, murder is first degree or second degree. Section 231.2, murder is first degree murder when it is planned and deliberate. So in the Valencourt case, they struck down felony murder because it is unconstitutional to convict somebody of murder where there's no mens rea requirement for the foreseeability of death itself. So murder cannot be a predicate offense. At minimum, there should be a foreseeability of death. So there has to be a mens rea for murder, basically. There are, though very few in number, certain crimes where, because of the special nature of the stigma attached to a conviction or the potential sentence, the principles of fundamental justice require that a mens rea reflecting the particular nature of that crime. Some examples are theft and murder. In the Nygaard case, it explains that planned and deliberate can also mean a planned and deliberate assault that is reckless as to whether it will cause death. If death ensues, the conduct that directly indirectly causes death must be planned and deliberate. From the Martineau case, adding to murder here, it is a principle of fundamental justice that a conviction for murder cannot rest on anything less than proof beyond a reasonable doubt of subjective foresight of death. From the Creighton case, the principle that the morally innocent not be punished underlies the mens rea requirement for criminal offenses. We require mental blameworthiness of a much higher degree to convict someone of murder. Section 231.3 through 6, circumstances elevating murder to first-degree murder are outlined in that section of the code. And in section 231.7, all murder that is not first-degree murder is second-degree murder. Okay, important notes. Remember, causation, netta test plus intervening X, Mabin test. And then in terms of sentencing, if that comes up, murder will be section 235, section 745A, Second degree murder will be section 235, section 745B and B.1 and C. And manslaughter will be sections 234 and 236. All right. Murder continued in terms of dividing the actus reus and mens rea. These are the elements that need to be proven here. The actus reus for murder. You have an unlawful act or criminal negligence, either or, causes death, where you would use the Netta test to determine, but for 231 subsection 5, then you'll use the Harbottle test of a human being. Use a Rizzo-Shoes test for that. And then voluntariness. And then you have the mens rea of murder, where you need intent or recklessness, and cite the mens rea cases that go to that. Subjective foresight, intent, or recklessness from the Martineau case. Knowledge or willful blindness, and then again cite the mens rea cases. So those are your elements. That's how you would most likely want to chart a question that requires you to break down the elements of murder. Continuing on to unlawfully causing bodily harm from section 269. Again, we're going to take a look at the elements needed to prove the act and the mental state, the actus reus and the mens rea. So from the actus reus, we need an unlawful act. We will interpret that using the Rizzo-Shoes case test. It can be a federal or provincial offense. That's from the De Souza case. Then we're going to look at the underlying provincial or criminal offense, which will consist of the conduct, the consequences, the circumstances, and the voluntariness. Voluntariness is a non-issue most of the time from the Rizzo-Shoes case. Then you have the consequence, which is causing bodily harm, Rizzo-Shoes, and causation. Apply the Netta test. Is it a significant contributing cause? Then we have mens rea, the mental state. We need constitutionally sufficient mens rea. We need to prove the elements of the underlying offense beyond a reasonable doubt. We need to prove that that satisfies the mens rea requirement for this element. And for this, unlawfully causing bodily harm, we also have the objective foreseeability of non-trivial bodily harm. So De Souza establishes this as a requirement for the predicate offense, because this is a predicate offense, despite the fact that there usually is no additional mens rea symmetry component for the causation analysis in a predicate offense. So again, this is one of those exceptions to a predicate offense that doesn't require mens rea, except here we have an objective foreseeability test required from the De Souza case. Moving on to manslaughter, sections 234 and 236. And here we have the actus reus elements as conduct act, unlawful act. Then we have the conduct, consequences, circumstances, and voluntariness. Break that down. Conduct, which would be omission, criminal negligence, subsection 219. We have the consequence, death of another person, and the causation. We're going to apply the Netta. Voluntariness, cite the relevant authority depending on whether the involuntariness is automatistic, NCR, or neither. We'll go over those terms in some other study guide probably. Mens rea, constitutionally sufficient mens rea from the Creighton test. Prove the elements of the underlying offense beyond a reasonable doubt, and that will satisfy the mens rea requirement for this element. And then, again, this is a predicate offense with the objective foreseeability test, in this case of death or non-trivial, non-transitory bodily harm, and that's from the Creighton case. Next, let's take a look at aggravated assault, section 268, subsection 1, a non-predicate offense. Finally, we have the actus reus, where the conduct is to apply force to another, from the Rizzo-Shoes, circumstances, no consent, Rizzo-Shoes, voluntariness, cite the relevant authority, consequence, wounds, maims, disfigures, endangers life, causation, apply the Netta test. Mens rea here, we have intent, we have knowledge, then we have the objective foreseeability of non-trivial bodily harm from the Godin case. So we do have to have intent and knowledge, and then we also have this objective foreseeability test in here. Interesting. Okay. Next we have sexual assault from sections 265, 271, and 276. Actus reus here Touching. Conduct is a touching application of force, direct or indirect, from the Rizzo shoes. The circumstance will be another person, Rizzo shoes. Circumstance is a sexual nature of conduct from the KBV and Chase cases. Case created a non-exhaustive list of factors to consider in determining whether the nature of the contact was sexual. This list was applied in KBV such that the accused's perspective on whether the contact was sexual was not determinative. Doesn't matter. Or at least doesn't matter critically. RV Chase. Non-exhaustive list of factors. The test to be applied in determining whether the impugned conduct has the requisite sexual nature is an objective one. Viewed in the light of all the circumstances, is the sexual or carnal context of the assault visible to a reasonable observer? Here are the factors you're looking for. The part of the body touched, the nature of the contact, the situation in which it occurred, the words and gestures accompanying the act, and all other circumstances surrounding the conduct, including threats which may or may not be accompanied by force. All those factors will be relevant. The accused's intent or purpose, as well as his motive, if such motive is sexual gratification, may also be factors in considering whether the conduct is sexual. Implicit in this view of sexual assault is the notion that the offense is one requiring a general intent only. In the present case, there was ample evidence before the trial judge upon which he could find that sexual assault was committed. Viewed objectively in the light of all the circumstances, it is clear that the conduct of the respondent in grabbing the complainant's breast constituted an assault of a sexual nature. This is quoted from the Chase case. Continuing on with the actus reus elements, circumstance must be an absence of consent, and this is coming from the complainant's subjective mental state from the Iwanchuk and from section 273.1. And also from Iwanchuk, the absence of consent is subjective and determined by reference to the complainant's subjective state of mind. The complainant either consented or not. There's no third option. Then we also have the Barton case. So in this, checked out the footnotes in the annotated code for section 273.1. Voluntariness, again, NCR, automatism, non-insane automatism, involuntariness. Cite your relevant authority for those. And let's move back to the mens rea for sexual assault. So you have an intent to touch from the Iwanchuk case. You have the presumption of subjective fault from the Thoreau case. You have knowledge from Iwanchuk, willful blindness from Briscoe. And then in KBV, it was clearly open to the trial judge in this case to conclude from all the circumstances that the assault was one of a sexual nature. The assault was one such that the sexual integrity of the child was violated. Knowledge, recklessness, willful blindness of absence of consent is the mens rea for consent. So these elements are tied together. Or where the accused claims mistaken belief in communicated consent. Most common way to prove this is demonstrate the accused's failure to take reasonable steps. Sans regret, Briscoe, and Iwanchuk case. Section 273.2 of the code, the statutory language of failure to take reasonable steps injects an element of objectivity into this mens rea requirement for sexual assault, as in it's not consent where... So per 273.2, the accused's belief that there was consent is objective. Okay, let's talk a little bit more about sexual assault and things like that in the next study guide. These are the elements of these specific crimes, and that'll conclude this study guide for now. Like this video, hit subscribe, hit that notification bell for more videos on Canadian law.